Save this post. Hi, I'm your AI business law clerk. Call me Gabrielle. Today, we will be exploring the recent updates in the world of business law with respect to civil and criminal liability for U.S. businesses. J.D. James and Associates PC is committed to keeping you informed about significant developments in the legal landscape that may impact your business operations. With this in mind, we would like to draw your attention to the recently enacted Corporate Transparency Act, or CTA, regulations and emphasize the importance of compliance. So what is the CTA? Entities formed prior to January 1st, 2024 must begin filings on the 1st. It is important to note that ownership changes made after January 1st, 2024 must also be reported pursuant to CTA requirements. We are beginning advisement and collection of required documentation now, as the CTA compliance process is extremely important as well as complicated. The regulations established by the CTA require corporations, LLCs, and other similar entities to disclose specific beneficial ownership information to the Financial Crimes Enforcement Network, which is also known as FinCEN. FinCEN is a bureau of the U.S. Department of the Treasury. This may include registered sole proprietorships. Entities required to file under the CTA mandate are called reporting companies. The CTA was signed into law on January 1, 2022. It aims to enhance corporate transparency and combat illicit activity, including money laundering, the financing of terrorism, proliferation financing, serious tax fraud, human and drug trafficking, counterfeiting, piracy, securities fraud, financial fraud, and acts of foreign corruption, harming the national security interests of the U.S. or its allies. The act was enacted as a result of an increased focus on money laundering in the U.S. According to the U.S. Congress, more than 2 million corporations and LLCs are formed each year, with many states failing to collect beneficial ownership information about the corporations, LLCs, and other similar entities. Congress aims to support national security, intelligence, and law enforcement, and to provide a reliable federal business standards framework that meets international standards. As a result of the CTA, reporting companies are now required to identify and verify beneficial owners. In addition, reporting companies must also report any changes to beneficial ownership information. Prior to the passing of the new CTA regulations, this requirement fell on financial institutions pursuant to the customer due diligence requirements of the Bank Secrecy Act. The term beneficial owner means an individual who, directly or indirectly, through any contract, arrangement, understanding, relationship, or otherwise exercises substantial control over the entity, or owns or controls not less than 25% of the ownership interests of the entity. The beneficial owner verification process involves submission of identity verification documents as well as other information under penalty of perjury. This burden shift comes with the imposition of fines, as well as more serious penalties, including imprisonment, for willful noncompliance and unauthorized disclosures. Compliance with the CTA regulations is crucial for all business owners, as the penalties for noncompliance can be severe. Entities failing to meet their reporting obligations or to update information may face penalties of up to $500 per day, ranging up to $10,000 in total, and/or imprisonment for up to 2 years. Additionally, the Act empowers FinCEN to impose the same penalties to any person who knowingly provides false or fraudulent beneficial ownership information, depending on factors such as the intent of the reporting company or beneficial owner. Other criminal liability may be attached in addition to CTA-related criminal charges, including but not limited to charges of perjury, in addition to violation of the Title 18 of the United States Code, which makes it illegal to submit false statements or claims to a federal agency. To ensure compliance and mitigate the risk of heavy fines and/or imprisonment, it is imperative for businesses to seek the guidance of experienced business legal counsel. As a business law firm, we are prepared to assist you in understanding and fulfilling your responsibilities under the CTA regulations. Our team has a deep understanding of the intricacies involved and will provide you with comprehensive guidance tailored to your specific needs to help ensure you reach and maintain compliance. Entities subject to reporting must provide information such as the legal name, date of birth, current residential or business address, and unique identifying number of beneficial owners. The entity must submit its own legal name, address, and unique identifier, which may be assigned by FinCEN. Compliance demonstrates transparency, accountability, and commitment to ethical business practices and can enhance your reputation, build trust with stakeholders, and provide a competitive advantage. We have extensive business counsel expertise at J.D. James & Associates PC. We are here to support you every step of the way, whether you need assistance in navigating the CTA regulations for filing purposes, or in the event that you have incurred fines or criminal charges in relation to the Act. We highly encourage you to reach out to our firm to discuss your specific needs and ensure compliance with CTA regulations. Our team of experienced attorneys is available to provide personalized guidance and support to protect your business interests. Follow us for more information on business law. You can also call or text us at 8444 James. That's 8444 552637.